Hi guys, this is Samuel Odhiambo Otieno, who is a senior law student at JKUAT, Karen Campus, Nairobi, Kenya. I would hereby like to take this opportunity to once again welcome you all to the Samuel Law Podcast and Academy YouTube practice, so that together we can walk this noble journey of getting to learn more about our laws. Welcome. So as was promised in our last session, today we are going to look at the elements of contract one by one, so as to get an in-depth meaning and understanding of what is entailed in a contract. Please welcome. So to begin us off today, we are going to start by offer and acceptance. And our objective today is to define both offer and acceptance. We are also going to identify the different types of offer and acceptance that can be applied to a contract. We shall also be able to understand the basic elements or characteristics of both offer and acceptance. And finally, we shall also be able to learn about the different factors that may lead to the termination of an offer. So let's begin in our introduction. For there to be a contract, an offer has to be made by one party who is otherwise known as the offerer, and this very same offer must be unequivocally be accepted by a different party who now becomes the offeree. An offer can be defined as an expression of willingness to contract on certain terms, made with the intention that it shall become legally binding as soon as it is accepted by the person to whom it is addressed, that is the offeree. It is actually an unequivocal manifestation of the offerer of a willingness to be bound by the terms proposed to the offeree as soon as he, that is the offeree, signifies acceptance of the terms. Let's look at the rules or characteristics that may affect an offer. An offer may be oral, written, or implied from the conduct of the offerer. 2. An offer must be communicated to the intended offeree or offerees, as it remains ineffective until received by such. Number 3. An offer must be clear and definite. That is, it must be certain and free from vagueness and ambiguity. 4. It may be conditional or absolute. The offerer may prescribe conditions to be fulfilled by the offeree for an agreement to arise between them. Number 5. An offer may be generic, it may be general or specific. That is, directed to a particular person, class of persons, or even to the public at large. Number 6. The offerer may prescribe the duration the offer is to remain open for acceptance. He is, however, free to revoke or withdraw it at any time before such duration lapses, as long as no acceptance has been received by him. 7. The offerer may also prescribe the method of communication of acceptance by the offeree, and if he insists on a particular method, then it then becomes a condition that must be followed by the offeree. And finally, an offer has to be made willingly. Let's now look at the types and contents of offers. Offers can be classified into two broad types, which are 1. Specific, and by specific that is made to a particular person or group of people, which means that only such group or persons can be able to accept it. And then number 2, we have general, that is made to the whole world or to the public at large, just as we have seen above, as particularly seen in cases of rewards and other public adverts. And what is contained in an offer? An offer contains 1. A proposal of the terms of the exchange, and 2. An expression of willingness to be bound as soon as the offeree manifests acceptance. What can lead to termination of an offer? Okay, the following factors may lead to the termination of an offer. 1. We have acceptance, that is by the offeree. Number 2, we have refusal or rejection by the offeree. A counter offer, lapse of time, that is, if the time that was given for such an offer has passed or has lapsed. We also have death of any party, be it the offerer or the offeree. Failure of a precondition. If there was a condition to be met and yet it was not met, then that automatically terminates the offer. And then ignorance of the offer. You cannot accept an offer that you are not aware of. Then we also have revocation, rescinding, annulling, or withdrawal by the offerer. That is before any acceptance has been made. After looking at offer, please now join me so that we can also look at acceptance. Acceptance can be defined as a final and unqualified expression of assent or unconditional agreement to all the terms of an offer. It is an unequivocal expression of consent to the proposals contained in the offer, which has the effect of immediately binding both parties to the contract. It actually locks the door on the contract room, as neither party can now get out of the contract or vary its contents. And what are the characteristics of acceptance? A valid acceptance must, 1. Correspond with the offer. It actually needs to be a mirror image. If we go by the mirror image rule. Number 2, acceptance must be in response to the offer. There must be a nexus between the acceptance and the offer. 3, acceptance must be made by an appropriate method. Number 4, it must be communicated to the offerer. This fixes the time of a contract formation, crystallizing the terms and making withdrawal impossible, just as we have learned above. 5, acceptance must be made while the offer is still in force. And finally 6, an acceptance must be absolute, final, and unqualified. That is, it must be accepted in total. Accept it as it is. So let's look at some of the types of acceptance. 1, we have express acceptance, and this is an acceptance. An acceptance is said to be expressed if it is made in oral or written form. That's express acceptance. Number 2, we have implied acceptance. An acceptance is said to be implied if it is made by conduct of the party. So what's our conclusion today? Offer and acceptance are two of the main ingredients or constituents of a contract which make an agreement legally binding or enforceable. For there to be a contract, an offer has to be made by the offerer, which must then be accepted unequivocally by the offeree. And at the moment that a contract is formed through offer and acceptance, each party now becomes bound to its terms. And just as we have seen above, they can neither desist from it or alter it in any way. They are now bound by its terms as it was accepted, as it was offered and accepted. Now let's take a recap of what we've just learned today. So in this module, we've been able to learn the meaning of both offer and acceptance. We've also been able to define and identify the different types of both offer and acceptance. We've also been able to understand the different rules or characteristics affecting offer and acceptance. And finally, we've also been able to learn about factors that may lead to the termination of an offer. Thank you very much, guys, for watching. I would like to welcome you also to our next module, where we shall continue to analyze further contract law by looking at all its elements one by one. Thank you and welcome. Do you have any questions or comments? Please kindly post them in the comment section below the video. Otherwise, thanks for watching this video. Please remember to subscribe to my YouTube channel, like the video, click the notification bell, and share with your friends and family or networks. Thank you.